So now we'll talk a bit about this second piece, this idea of consideration. So again, consideration is a bargain for something in exchange in a contract. And this is what makes your promise to do something nice for someone something legally enforceable. Again, if you promise to take your nephew to Disneyland and you don't take them, what of value is your nephew giving you? Can't just be like emotional satisfaction, right? So if you bail on that, it stinks you broke your promise, but it's not enforceable in a court. You know, he can't bring you to court and say, you promised you're taking me to Disneyland. Because the court's going to say, well, what was your nephew going to do for you? That's where consideration comes in. What is being bargained for in exchange? So it means there has to be a bargaining that leads to an exchange between the parties. And it can be anything you might want to bargain for. Okay, so examples of that. The big one we talk about in terms of business, it's usually what? It's on the screen. Money, right? So usually it's, I'm going to give you money in exchange for these services. They can also be a promise or action. So over here, if you have a legal right to do something, I have a legal right to smoke cigarettes. I'm over 18, I can smoke them. If I give up that legal right, it's a promise to do something I have a right to do, that can be considered consideration. I'm giving up something of value. Now, a benefit, there has to be some type of benefit to one, could be a detriment to the other. You're paying a company $100, you should be getting something of value, and it's a promise to do something or refrain from something. Again, something of value being exchanged. Normally in business, this is money. It doesn't always have to be. So I've mentioned some examples of this before. Another example I'll give you, my sister's business I've told you about before, that child care. One of her parents was an attorney when we were trying to get some licensing done to get the zoning on the next business. He did this type of thing. He kind of specialized in it. So instead of charging him a bill every month for his child to attend her child care, she simply exchanged his services. So she got to have some legal work from him. You know, they had a set number of hours she would get from him. And in return, he didn't have to pay a child care bill for a little while. So you could exchange services as long as it's something of value. So the interesting thing under the law, the thing of value doesn't have to be what the law calls adequate. The big thing they'll say in contracts, my contracts teacher said this, years ago when I was at the law school, and it stays today, a mere peppercorn will do. How much money would you pay for this little peppercorn? Like a penny? I wouldn't even pay anything because it's a lot of work to grind it up, right? What do we need pepper for right now at 9:30 in the morning? Yeah, so in the law, we say a mere peppercorn will do. Does it have some value? Yeah. So, if that peppercorn looks like my grandmother's face, I might be willing to pay hundreds of dollars for it. That's ridiculous, right? The court's not going to go, that's ridiculous. There's no value in that peppercorn. And the idea here is the court will say, we're going to assume there's value. Okay, they'll seldom try to decide whether or not it was an adequate form of consideration. Whether or not me giving you $200 for a peppercorn is really enough value. They're not really going to usually look into that unless it seems like I'm being taken advantage of. If I want to fight with someone and pay $200 because that peppercorn looks like my grandmother's face, I can do that. The court's not going to question it generally. Okay, so most courts, as long as it's something of value, they're not going to question whether or not it's enough money, that the contract had a reasonable amount.
So you will determine how much you pay.
Yeah, you can determine how much you pay. So, you might be like, I want to get out of town, I'm selling my car, I'm going to sell it for $100, I don't care, I know it's worth more, but I want to sell it to my friend Sinya, so I'm just going to go ahead and sell it. $500 cash, is that good? The court's not going to go, well, the car was worth $5,000, why'd you sell it to Sinya for $500? Unless, again, it's an issue of maybe I'm taking advantage of her. Does it sound like I'm taking advantage of her? No, she's taking advantage of me. I'm getting out of town and she's buying my car for $500. So they're not going to normally look into whether or not the amount of money is adequate. Now, if you make a promise that is in some way conditional, you as the other party, you're not going to be bound to the agreement. So if someone says something like, I'll give you $100 if you fix my car, does that sound like something of value? Yeah, so that could be consideration. But then I say, but if I don't, you can't take action. Well, now I've made it really conditional. If they don't fix the car, is there anything that they can do? No. So now we don't really have anything of value. I'll give you $1,000 to fix my car, but only if I feel like it. Have I really promised to give you any money? No, I've made it conditional. It's only if I feel like it, so really there's not guaranteed value being exchanged. That's what we call an illusory promise. You know, they're giving you something, but there's kind of strings attached to it. Now this is a big one. See the cute little girl with the telephone? This idea is called a pre-existing duty. It's a promise to do something you already were obligated to do. That's not going to be consideration. So if I'm saying, oh, I promised to, come to class. You're already supposed to come to class, right? So to have something of value, you need to be promising something you weren't already obligated to do. My favorite is like, I promise not to murder anyone. Should we not murder anyone anyway, right? So promising to do something that you're not already obligated to do. Now here, an example of that, this girl's saying, I promise not to drink alcohol this year. What is the issue with that?
She's a child.
She's a child. Why does that matter, Allison, that she's a child?
Because she shouldn't be drinking anyway.
Yeah, she definitely shouldn't be drinking. That's some failed parenting. She should not be drinking anyway. Who can drink alcohol? Over 21. We can all agree she's definitely not 21. Okay, so she doesn't have a legal right to do that. She shouldn't be drinking anyway, so she can't say, I promise not to drink alcohol. She's really not giving up anything, right? Wasn't supposed to be doing that in the first place. So that's a big one. To give up something, it has to be something you have a legal right to do. So I have an example of that to illustrate this for you. Again, it's a classic case. It's a little old. It's Hammer versus Sidway. There's this guy named William Story, and he wants his nephew to grow up healthy and prosperous. So again, we're in the 1800s here. He promises the 15-year-old boy $5,000 if he'd refrain from drinking alcohol, using tobacco, swearing, and playing cards or billiards, so gambling, for money until his 21st birthday. That seemed like an uncle just trying to make sure his nephew turns out to be a good kid. Yeah. So the nephew has a legal right to do these things. This is important. It's 1869. At this point, he still has a legal right to do a lot of these things. If this was today, would he legally be able to drink alcohol at 15? Gamble?
No.
Okay. So keep that in mind, given the time frame. When he reaches his 21st birthday, the nephew notifies his uncle that he had honored his agreement. So what did the uncle offer?
$5,000.
$5,000. And what was the value being exchanged from the nephew? Yeah, no fun stuff, right? He's giving up his legal rights to do all the fun stuff. So the uncle congratulates the young man and promises to give him the money. But now he says, I want to wait a few more years before I hand over the cash. He thinks the nephew's not mature enough yet. He wants to wait till he's like 24. He dies. And his estate refuses to pay. So when you die, you have what we call an estate. Okay, someone who's responsible for all your stuff. And they get to kind of decide based on your wishes where it goes. So for example, if I die, my home and the value of my home would go to my husband. Even if I don't state that in a will, usually the state has what we call probate, certain rules about next of kin, like who's kind of next in your family to get your stuff. So here, his estate's saying, well, we're not going to pay this debt to your nephew. They refuse to pay it. And so they say, the uncle dies and refuses to pay. Hammers, this person who the nephew transferred his rights to, he sues the estates and says you have to pay. Hammer versus Sidway. Okay, Hammer, is this the nephew? So the nephew made a promise. He said, my uncle's supposed to give me $5,000. Hammer, in a few years, I know I owe you some money. I'm going to give you, this benefit I have coming. I'm going to transfer it to you. When my uncle does pay, you're the one who gets to collect. That's also part of the reason we see the estate saying, no way, we're not going to give this to you because it's not even one of the family members in the end. So they argue that the nephew had given no consideration for the uncle's promise. And the trial court found for the plaintiff and the uncle's estate appeals. So they're just saying like, hey, we don't want to give this money to Hammer. So did the nephew give consideration for the uncle's promise? In this case, did he? Yeah. So they said, you know what? He gave valid consideration. And this is the case that basically set the precedent that you refrained to do something you were legally entitled to do. That's considered consideration. Helped illustrate that for you? Okay, but just keep in mind, if it was today, that would not have been the case. Now the other piece of this, comparing settlements of debt. Okay, this is another big thing. I'm going to give you some tips that'll help you as you're making agreements with different businesses and different people. We're going to talk today about liquidated debt versus unliquidated debt, and then the last piece of this has to do with checks. Anyone in here still write checks sometimes? Yeah, so we're going to talk about why the memo is so important on your check. So the first piece of this, liquidated debt, it says liquidity. That's when you look over your investments and what you're paying. Okay, what is liquidity really? In terms of value. What is something that's a liquid, we say asset, thing we have. What does it mean to have a liquid asset, John? Yeah, cash is usually what we're talking about. You know, something you can use quickly. You might have something with a lot of value. You could have $1 million home, but if tomorrow you need that $1 million, are you gonna be able to get it? No, it can take a year to sell a home. So it's a liquid, how quickly we can use that thing of value. A liquidated debt is one in which there is no dispute about how much both parties owe. Okay? If there's no dispute about how much is owed, the creditor agrees to take less than the full amount as full payment, the agreement's not binding. If you both agree, I agree, I owe Macy's $1,000. Macy's agrees too. Macy's says, you know what, Hannah, you're a good customer, you can give us $600. What have they given up? $400. So is that something of value to Macy's?
Yes.
What did I give up? Nothing, right? Did I give anything up in exchange for that money? No, they were entitled to that full $1,000. So here, it's not binding. If they go back and say, we want the full $1,000, they can do that. It's like they made a promise, but there's no consideration when they offer me to pay a little less. Okay, so if the debtor offers a different performance, and the seller agrees, then it's binding. So if I offer Macy's $600 for that $1,000 debt, and Macy's agrees to it, now it's binding. Because I am giving them only $600. They are giving something up. They're giving up that $400, but they're agreeing to give that up. They were the ones who had the legal right to it. They can promise to refrain from getting it. So again, if the creditor agrees to less money, it's like they're doing something nice. There's nothing being exchanged from them. It's not binding. If I ask for them to give something up and they agree to do it, now it will be binding. So this comes into play a lot. Let's say I don't pay Macy's that $1,000. Instead, I'm so in debt, I have so much credit card debt, I go bankrupt. How much money did Macy's get for that $1,000 debt I built up? Nothing. So you actually see this a lot. Lawyers will help people who are getting close to declaring bankruptcy and not paying off any of their debts. They'll negotiate with some of these companies and say, listen, you're going to get nothing. Will you agree to take $500, $600 instead of the full $1,000? And often they will, because then they get something instead of, this person's declaring bankruptcy. It can be a way to avoid someone like me having to declare bankruptcy, hurting my credit, and being in a bad financial place for 7 years. So we see a lot of these negotiations over debts with these companies. Be careful when you take out a credit card, right? Unliquidated debt is considered unliquidated if the parties dispute whether the money is owed, and the parties agree that some money is owed, but they dispute how much. So basically, if we don't agree that there's a debt and about how much that is, it's considered unliquidated. The parties in this case may agree to settle for less than what's owed. This accord and satisfaction is what we call it, will be enforced if the debtor pays the agreed amount. So if we dispute about how much it is, okay, and then I agree I'll pay $600 of whatever it is, and they accept that, and I pay that $600, I've paid my debt. Now down here, that comes into play when we talk about accord and satisfaction in terms of checks. So under the common law, and this doesn't apply to businesses selling goods, under the common law, if you write in the memo something like full settlement on a check, and the creditor cashes it, the payment is in full whether or not it was the right amount. That's sneaky, right? So, you owe a bunch of money to a credit card company, you give them this payment, you say, I paid in full, it's a full settlement, and they go out and they cash it, even though it's less than how much they were expecting. It's like they've accepted that offer that you made, and it's all of a sudden cleared out that debt. Now, under the Uniform Commercial Code, this is a little different. If this is a business setting, You know, it affirms that ruling, but it adds a couple exceptions. Organizations may notify debtors that any offers to settle debt for less than the whole amount must be directed to a certain person. So I can say, Macy's, you know, here's my debt paid in full, but, you know, Joe Schmo at Macy's has to approve it. If it's not Joe Schmo approving it, even if they cash it by accident, it's not going to be paid in full. They can also refund the paid amount. So while I said paid in full, you know, what'll happen is someone clerical will just go through, they'll cash it, you know, and then they're going to go, shoot, now we're out $400. They can, within 90 days, give that money back and say they want the full amount. Okay, so it's a little sneaky, but there's some protection here. The reason this becomes important is if you run into a situation, which I'll speak to an example of. I told you I had that apartment for rent in Massachusetts. It flooded. The insurance company was offering to pay a certain amount. We were running into issues because there's a condo association insurance company as well. So while for my residence they would cover up to $10,000, that was the limit, then the condo association's insurance would kick in. They wouldn't pay more than that amount. Now we were disputing that. We were saying that's not fair. Then the condo association gets to collect all this money for our condo, and we're the ones doing the work. We went in and did it ourselves and got the work done. We're like, that's not fair. You know, we want our money. So when this insurance company I had, Travelers, gives me a check for $10,000 and I'm disputing that amount, should I cash that check yet? No. So that's an example where I was weighted. So if I cash it, they're going to say, oh, you accepted the $10,000. We're not up for a dispute anymore. I wanted to have time to argue with them and not show them that I was accepting basically their $10,000 offer and saying, I agree with you, that's enough. Okay, so it's important on your checks that you, in the memo, write what they're for. It's like you're making a contract agreement. And then on top of that, that you're careful. If you don't agree with the amount, don't just cash it so you can take the little bit you wanted. Make sure that if you're cashing it, you're not accepting that in full. You could run into some issues. So I have some helpful tools for you to help you remember some of this stuff because it's a lot of information, right? So let's look at some of these helpful tools. If you click on that link, I don't want to continue. Down here you'll see some helpful devices. So for example, up here, the ingredients for a valid contract, we've discussed them, they're on the board many times. Who likes tacos? There we go. So that'll help you remember. You need to make sure you define the terms, that there's an acceptance of the terms, there's consideration, and an offer inviting acceptance. The offer expires. So we talked about some ways they can expire. Tired is a good way to remember that. So things like reasonable time periods, mental incapacity, revocation, express rejection or destruction of the property. We talked about that last class. Down here, some of the defenses, contract breaches. We'll learn this later on when it talks about writing, what contracts have to be in writing. A good way to remember that is my legs. Okay? M is for marriage, Y is for the year. You'll learn about legs, the land, E, the executor, G, the goods, and S, that last one for surety, paying the debt of another. So a lot of helpful little pieces of advice here for you. So that's a good link to help you remember. All right. Now I have an activity for us. So I'm going to stop the recording and we can do that activity now. Got all of our elements of the contract.